Well, good afternoon. It's a pleasure to welcome you all here to the Family Research Council. I want to thank all the people who've taken time out of their day to attend and all people online who are listening. So just wanted to make a quick point that all of our lectures are archived, and I think there's a sort of a previous lecture sub-tab on the website. You can go find very high quality, nice recordings of lectures that we've done in the past. So getting back to the topic at hand here, I think one of the things that's sort of become obvious at least in the Republican primaries, is that, the primary campaign as it's manifesting itself is this, and maybe even in the Democratic side with Bernie Sanders, this recognition that people are interested in outsiders, that they're kind of sick of Washington, and they feel that something's wrong in this city at various levels. A lot of people, I think, sort of felt this about the Supreme Court itself with decisions that it gave in Obamacare where Justice Roberts just seemed to ignore the statute and do what he wanted. And then in the marriage decision where we also had just sort of social policy being imposed on the United States. Well, on another level, one wonders, how is the Department of Justice doing in terms of its enforcement of the laws, the criminal laws? And we're fortunate enough to have a guest today who will be able to talk about that. And she's written a very powerful, I would say overwhelming book. Her name is Sidney Powell, and the name of the book is License to Lie, Exposing Corruption in the Department of Justice. And she served for 10 years in the Department of Justice. She was a lead counsel in hundreds of appellate cases and has had quite a distinguished career as an appellate attorney there. And when you read the book, you can see why. But the book is not a feel-good book. It's not one where the good guys win. It's sort of like the good guys lose, 28-21. That's not a great feeling. Maybe one person comes out of the book, Judge Sullivan here in Washington, as sort of as somebody that you're glad is on the bench. Most of the judges seem barely competent, or at least that's probably a charitable way to put it. And then the prosecutors that she talks about are not even barely competent. That's if they were only incompetent, that would be a step up for most of them. Her experiences came out of working with the appeals of a defendant in a case related to the whole Enron debacle. And as it turned out, virtually all of the Enron and the sort of the Enron task force convictions were overturned. And then by means of personnel and some subject matter, the case is also related to that of Senator Stevens' case here in Washington, D.C., which was one of the most, just blatantly disgusting miscarriages of justice probably in modern times. But let me hand things off to Ms. Powell, and she can tell us all about this. So here, without further ado, is Sidney Powell.
Thank you, Chris, and thank you to the Family Resource Council for having me speak today, and thank all of you for your time and coming to listen. All we have of our lives is our time, so I think it's the most important gift we can give anybody. License to Lie, Exposing Corruption in the Department of Justice is the book and the title of the book. I never set out to be an author. I decided when I was 5 years to sit down and watch Perry Mason. We didn't even have any lawyers in the family. Now, how I developed that, I have no idea. I will tell you that I came from a basic traditional family. My dad worked for GMAC. I don't think he ever made $20,000 in a year. My mom stayed at home. We had what we needed and lots of love. My father's sense of integrity was so great that he literally would not take a personal phone call at the office. He felt like all of his time at work was to be devoted to his employer, and he would not even accept a personal phone call at his office. with that kind of, and every time the church doors were open, they were both there. People who read the book often ask me if I have bodyguards and if I'm afraid, and how I got the courage to write the book. And I said, well, it didn't occur to me to be afraid. I have kind of a 4-part answer for that. The first is God didn't give me a spirit of fear. The second is I'm Presbyterian. The third is the horse is already out of the barn. And the fourth is I'm happy and healthy and I'm not doing any skydiving. So if anything happens to me, everybody will know exactly where to look. Any accident, anything, they'll know where to look. In the process of representing one of the Merrill Lynch executives in the Enron litigation, I learned a lot of things, some of them about myself. I knew when I accepted the case it was going to be a life-changing experience. It was just a massive case. One of the chapters in the book is entitled 800 Boxes because literally 2 FedEx ground trucks loaded to the hilt pulled up to my office and unloaded the entire contents of both of those trucks into it. It was 800 boxes of material, and I didn't get involved in the case until on appeal. So there was a lot of material to digest. But from the time I first met the defendants, and my defendant in particular, Jim Brown, my sense of everything that had gone on in Enron and in Merrill Lynch and even in Arthur Andersen was changed. He wasn't who I expected him to be. I found that I had the same bias and prejudices that most of America had, that you hear about the Enron collapse and you think automatically that everybody related to Enron is corrupt. That's all the press was reporting. In fact, all the press was reporting nationwide was the government's view of the case against Arthur Andersen, against the Merrill executives, against the Enron broadband executives, even against Skilling and Lay. That we were fed that daily. In fact, the Houston Chronicle, I think at one point, had 21 reporters assigned just to cover the Enron scandal alone. So there was this constant barrage of the government's view of everything bad at Enron. I really hadn't paid much attention to any of it other than thinking, oh yeah, they're all corrupt, until I got a call one day asking me to consult on the Arthur Andersen matter. That case, too, was well along by the time I got that phone call. People usually call me when the ox is kind of deep in the ditch. I do federal appeals in complex commercial litigation, and I've done over 500 of them, and for some reason people wait until the ox is large ox in a deep ditch, and then they call me. But I get the call on Anderson's to see if I can help with that. I get into the record. Fortunately, Maureen Mahoney at Latham & Watkins, they decided to hire her to be lead counsel schedule and start over. But Maureen and I had agreed without knowing it in our interviews with Andersen on what the key issue should be in the case, and that was the jury instruction and the fact that the Arthur Andersen indictment had been created by piecing together parts of different statutes to make a crime where there wasn't one. Arthur Andersen employed 85,000 people. It was destroyed knowingly and deliberately by our Department of Justice upon issuance of that indictment, because they knew that a company like Andersen that represented 2,500 publicly traded companies could not survive a federal indictment. So they destroyed Andersen deliberately. Why did they do that? Because then, once they knocked on the door of any company that had done business with Enron, that company knew it would have to cough up whatever the Department of Justice wanted them to cough up, whatever scalps they wanted, whatever documents they wanted, anything the Department of Justice wanted would have to be given to the Department of Justice to avoid being dealt the death penalty that the Department of Justice dealt to Arthur Andersen. It took a couple of years of litigation in Andersen. Well, let me back up a little bit. Andersen was destroyed upon release of the indictment. Shareholders, not shareholders, but people who had done business with the company piled on filing civil suits. Of course, all the publicly traded companies had to find other representation. In fact, the department sealed the indictment for a week so the SEC could work behind the scenes to avoid upheaval in the markets once the indictment became public. So all that was happening behind the scenes with full knowledge that they were destroying Arthur Andersen and its 85,000 jobs. The indictment's unsealed. Andersen goes to trial, if you can call it a trial. Much of the evidence Andersen kept, including it kept some form of every document it supposedly shredded. Were they cleaning up the files? Were they shredding documents? Yes. What were they actually charged with? They were charged with witness tampering, because Andersen was under no legal obligation to keep any of the documents that it shredded. So it had no legal duty to retain the material that the government was prosecuting it for shredding. There was no evidence that it shredded anything improperly, and it charged them with witness tampering. It only took the jury, I think the trial was 6 weeks or so, and Andersen was tried within just a few weeks of the indictment being issued. It really was, I think, only 3 months from the time of the Andersen indictment to Andersen's conviction. The judge in Houston, Melinda Harmon, gave the prosecutors whatever they wanted, including a jury instruction on the intent that was required for Andersen, because one of the key witnesses, David Duncan, an Andersen partner, testified that he believed at the time that all of his actions were lawful. He had pled guilty because the government had bludgeoned a guilty plea out of him, threatening to send him to prison for 30 or so years so he'd never see his children or his grandchildren for this outrageous conduct. So he had pled guilty, but when he testified, he continually explained that he believed his conduct was lawful. Well, lo and behold, a couple of years later, the Supreme Court says, yes, his conduct was lawful. What Andersen did was not criminal at the time. That prompted Congress to enact Sarbanes-Oxley, which now, of course, they refuse to enforce against Hillary Clinton for her knowing destruction of evidence before any Benghazi hearing or anything else. But Justice Rehnquist wrote in his decision, not only was the indictment flawed, but that the jury instructions, it was shocking how little culpability the jury instructions required. So they took all the criminal intent out of the jury instructions to convict Arthur Andersen. So you have deliberate destruction of a 75-year venerable institution, literally the gold standard in accounting for a long time, 85,000 jobs destroyed. And what'd the prosecutors do next? Next, this group of hand-picked elite prosecutors, picked, mind you, by Michael Chertoff under the Bush administration, but many of them were also assistant general White House counsel during the Clinton administration. One of the things I've identified is just this incestuous in and out of a certain group of people between the Department of Justice and law firms and particular administrations. It's phenomenal. We now have what I call a corrupt cabal of prosecutors from the Enron task force that are running the government in any number of areas. But to stay with some sense of chronology, the Enron task force prosecutors that convicted Andersen were Leslie Caldwell, Andrew Weissman, and Matthew Friedrich. And there was one other at the time, but to avoid getting too complicated, I'll stick with those three for now. They went on to, Caldwell left after Skilling was indicted, Layan Skilling, the Enron CEO and chairman of the board. She left the task force and turned it over to Andrew Weissman. They then indicted the Merrill Lynch executives in what was known as the Nigerian barge or Enron barge case. I won't try to explain to you the details of the case, but basically it turned on a 5-minute phone conversation on a December 23rd afternoon between 6 different people. And according to the government, the entire crime consisted of Merrill making a guarantee to Enron Enron making a guarantee to Merrill that Enron would buy back these barges. It was a little $7 million investment by Merrill, which to us obviously is a lot of money, but to Merrill and to Enron, which I think was a $400 billion corporation at the time, it wasn't material enough to be charged as a securities transaction. So there was no securities fraud alleged. Instead, the government comes up with this new charge. They're going to indict, and they did indict, the Merrill executives and a few Enron people for depriving Enron of the honest services of Andrew Fastow. If you remember anything about Andrew Fastow, it would probably be that if his lips were moving, it probably wasn't true. To imagine Andrew Fastow having given honest services during any day of his service at Enron would be a stretch. He was admittedly the architect of every fraud at Enron. He was the one that set up the special purpose entities that he was using as his own personal piggy bank. He would tell the seller of Enron as a seller that a buyer would pay $20 million for something. He would tell the buyer that Enron would only sell it for $40 million, and he would keep the $20 million for himself in between. So that's how Fastow made so much money and did so well for himself at Enron. He was actually the one that was stealing money from Enron. He and a couple of his associates, Copper and Glisson. So to make their case against the Merrill defendants, the government doesn't go to any of the people that were actually on the telephone call that they say constituted the crime. Since they had charged this conspiracy to defraud Enron of the honest services of Andrew Fastow, they went to Fastow's subordinates and with whom they had made sweetheart plea agreements. So they let off the guys who actually stole money with very sweet deals. In fact, Fastow himself got less than 5 years in prison. And Fastow didn't testify in the Merrill Lynch case. Instead, Copper and Glisson testified as to what Fastow had told them about the Merrill Lynch Enron conversation. At the same time, I find out 6 years later, of course, the trial lawyers are screaming the whole time, we want Brady information. We want the information from the people that were actually on the phone call. We want to know what the real witnesses to this said. And under the Supreme Court's decision in Brady versus Maryland, I'm going to assume there's some non-lawyers here, the government is required, a prosecutor is required to give the defense evidence that shows the defendant's innocence, or even raises a question that he might not be guilty, or that the transaction is different than the government says, or that some of its witnesses said something different than some of its other witnesses said. It's a constitutional requirement, it's a legal requirement, it's an ethical requirement. Prosecutors, unlike other lawyers, have a duty to seek justice and to uphold the law, even if that means letting a guilty person go free. The Enron Task Force prosecutors didn't do that. By the time of the Merrill trial, the prosecutors were supervisor, now head of the Enron Task Force, Andrew Weissman, Matthew Friedrich, who had been on the Andersen case, and now Catherine Rumler, newly appointed to the Enron Task Force, had been assistant White House counsel in the Clinton administration and a high-ranking prosecutor somewhere else. This group, it took me 6 years to find out, had actually yellow highlighted the evidence that showed the Merrill Lynch defendants were innocent and hid it for 6 years, while 4 Merrill Lynch executives went to prison on an indictment that didn't state a federal offense. The honest services charge did not apply in a case like this. It was another Andersen instance of they pieced together parts of different statutes to make up a crime where there wasn't one. We could not even get them bail pending appeal because of the outrage in Houston. We couldn't get the Fifth Circuit to award them bail pending appeal, this circuit that I've practiced in front of for so many years that I think I represented the government in more than 350 cases standing in front of this court, and I would stick a stick in my eye before I would tell the court something that wasn't true. They knew my reputation. They knew my credibility. It made absolutely no difference in this case. I even sought rehearing of the denial of the bail pending appeal issue on the honest services charges in the indictment because I knew there wasn't a single case in the country that would serve as precedent for charging these men with depriving Enron of the honest services of Andrew Fastow. And that was the guts of the entire indictment. They also threw in two additional charges against my client, Jim Brown, alleging that he committed perjury and obstruction of justice. Listen carefully to this. For expressing his personal understanding of a telephone call that he was not even participating in, after the prosecutor and the grand jury had said, "Please share with us your personal understanding, whether it is accurate or not." And that formed the basis for a perjury and obstruction conviction that he still has to this day. We managed to get the Fifth Circuit to reverse 12 out of 14 counts of conviction against the defendants. Our youngest Merrill Lynch executive, Bill Fuse, 32 years old, had worked for Mr. Brown in the asset management and leasing department. He had just done ministerial duties and what he was told to do to get the thing papered. Oh, and by the way, it had all gone through Merrill Lynch general counsel, but that's part of the evidence we didn't get as to what she had said and advised and how she had shepherded the entire transaction through Merrill Lynch's approval process. We were denied all of that evidence for the trial and even for the appeal. But Mr. Brown, Mr. Fuse, the young man, wound up being acquitted on appeal. And this is after he had served 8 months in a maximum security federal transfer facility in Oklahoma, 600 miles from his young family, with the worst of the worst federal prisoners. Department of Justice will tell you that it has no control over where people serve their sentences, that it's all within the control of the Bureau of Prisons. That is hogwash. Ben Glisson, one of the young treasurer of Enron who wound up making the plea agreement or some sort of deal with the government, actually he refused to plead guilty to begin with. Then he decided he would plead to, he got a deal to plead to 1 count, but he wouldn't make any deal with them to testify. So he just went and pled guilty to 1 count. They wanted him to testify. They took him from the street basically, and put him straight into solitary confinement. If you know anything about solitary confinement, it is literally a box with a slit for light. It is smaller than the size of a parking place in a parking lot. They're always roach and rat infested, and it will drive any sane human being crazy within a matter of hours. So Ben Glisson stayed in the solitary confinement until he was ready to sing for the government. Imagine how that happened. So he was one of the witnesses in the barge case. And it turned out when we finally got the evidence that the government had yellow highlighted, that even Fastow himself had given evidence that contradicted Ben Glisson's testimony at trial or explained that testimony. And the actual people who were on the call, Fastow and Enron treasurer Jeff McMahon, agreed that there had been no guarantee given to Merrill in the barge case whatsoever. So the whole issue that the barge case turned on, whether there was a guarantee to buy back the barges, was false, was determined false by both Fastow and McMahon, who were on both phone calls and who hated each other's guts. So for Fastow and McMahon to agree on anything was another major revelation, not to mention the fact it completely exonerated the Merrill defendants. We couldn't get them a new trial based on the new evidence. And worse than that, we couldn't even get the federal judge, Ewing Werlein in Houston, to acknowledge the yellow highlighting. We did a series of briefs asking for a new trial because the evidence had been withheld, and neither the government nor Judge Werlein, in a 66-page opinion, even acknowledged the existence of the yellow highlighting. We were ships passing in the night. I mean, we even attached the physical yellow highlighted pages to our motion, and everybody acted like it wasn't there. When the prosecutors had yellow highlighted it in full recognition that it was crucial to the defense, that it was Brady material, and had surgically excised it from the very narrow summaries they had given the defendants pretrial. I found that so offensive, I couldn't sleep. As you read the book, you'll follow, I'm sure, some of my emotions and probably have some of your own as people tell me that, yes, the book makes them very angry. There's also an interesting dichotomy between the Ted Stevens case that has some overlap with this and the Merrill Lynch case, because the judges in the two cases are so different. Judge Werlein in Houston was phoning it in at best. He's hoping he never sees me in his courtroom again. There's one scene where I almost had a stroke, I think, literally. I'm sure I left my fingerprints in the podium. I was so angry. Judge Sullivan, on the other hand, in the Ted Stevens case, which is also discussed in the book, wound up appointing a special prosecutor to investigate the Department of Justice itself for its corrupted prosecution of Senator Stevens. And guess who led the corrupted prosecution of Senator Stevens? None other than Matthew Friedrich, one of the Merrill Lynch Enron task force prosecutors and one of the Arthur Andersen prosecutors. Friedrich catapulted to the top of the Department of Justice and was acting assistant attorney general for the criminal division of the Department of Justice, who rushed the Stevens case to indictment. And then, as we learned in Mr. Schulke's report, the special prosecutor micromanaged the Stevens prosecution to the nth detail. The only thing that isn't documented in that is the extent to which he may have influenced the failure to produce evidence exculpatory to Senator Stevens, because Mr. Friedrich and Rita Glavin, his deputy, were not named in the contempt order or the investigation issued by Judge Sullivan because they were so high up in the department. He named the actual prosecutors during the trial. The book reads more like a novel than a law book. At least that's what even non-lawyers tell me. It's written like a John Grisham novel. I hope he doesn't mind that analogy, but I've heard it is a fast read. And one that hopefully will hold everyone's interest. But it's extremely important. There is a human toll to prosecutorial misconduct that people want to ignore. It destroys lives. A prosecutor is one of the single most powerful people in the country. With the stroke of a pen, he can have someone indicted. Justice Robert H. Jackson, back when he was Attorney General on April 1, 1940, made a famous speech called The Federal Prosecutor. It's literally enshrined in legal history. There may be portions of it that are chiseled into the walls of the Department of Justice, or he took some of his lines from that. But a federal prosecutor has a sworn duty to seek justice. I have stood in the Fifth Circuit Court of Appeals and said, I'm sorry, judges, our agents botched this case. We didn't handle this properly, or, this was not a fair trial. It's called confessing error. And that's what a Department of Justice lawyer is supposed to do when something is wrong. These lawyers knew these things were wrong. They did it on purpose. There's no way it could have been done by accident in the Merrill case in particular. And those prosecutors became, let's go by name. Catherine Rumler, lead co-counsel in the Merrill case, was President Obama's longest-serving White House counsel. Lisa Monaco, implicated in any number of misconduct allegations in the Enron broadband case, is still President Obama's chief counterterrorism advisor. Leslie Caldwell, who headed the Enron task force through the Andersen indictment trial and up to the Skilling Lay indictment, is now head of the criminal division of the Department of Justice, the world's largest criminal conviction machine. Andrew Weissman became chief counsel of the FBI / deputy director of the FBI, and is now back at the Department of Justice, reunited with Leslie Caldwell as head of the corporate fraud section, getting ready to target business executives again under the new Department of Justice policy. This is what I call the corrupt cabal of prosecutors, all of whom came from the Enron task force, who found their way into the highest echelons of our government with absolutely no regard for their history and conduct in these cases. When we couldn't get the Fifth Circuit to fix any of this, Bill Hodes, who's one of the 3 leading legal ethics experts in the country, and I filed grievances against all of them with the bar associations, their respective bars. The Texas bar bounced the grievance against Matthew Friedrich like a rubber ball. Never mind, it was 30 pages long, filled with citations, and Mr. Hodes has a reputation that's absolutely stellar as a legal ethics expert. The one against Catherine Rumler filed in D.C., there were actually 2. One was swept under the rug before she became assistant White House counsel while she was still at DOJ, and the other one just seemed to have kind of turned to dust and wafted away in time for her to be promoted as chief White House counsel. And the one against Mr. Weissman, while he was head of the FBI, was being investigated supposedly by the New York Bar Association, but he was being defended by Department of Justice because he worked for the FBI. He was entitled to defense by Department of Justice Civil Division lawyers on his grievance. All of a sudden, we find out weeks after it happened that the New York Bar Association decided that the Office of Professional Responsibility at the Department of Justice should really be the unit to describe and decide the matters regarding Mr. Weissman. So they punted the whole grievance to Department of Justice. Now you have the Department of Justice both defending Mr. Weissman on this grievance and deciding whether Mr. Weissman committed any grievable offense. You can probably guess how that came out. No problem. So now Andrew Weissman is back as head of the corporate fraud section at the Department of Justice. You know, I wish I could tell you that things were better. It turns out also that Loretta Lynch and Andrew Weissman and Leslie Caldwell go way back with relationships with each other in the U.S. Attorney's Office in New York. I've written a number of articles on the New York Observer at observer.com. The first one was called All the President's Muses. I was struck by a picture of President Obama sitting with Catherine Rumler on his left, actually to his right, and Lisa Monaco on the other side of him, both Enron Task Force prosecutors who I knew had committed prosecutorial misconduct. So that was an interesting article that wound up getting a Drudge hit, along with a number of others that I've written, because all of the people in the book are still in current events. There's been a significant effort to kill this book with silence. The New York Times, of course, refused to review it. The New York Post was going to write an article on it, but pulled it after reaching out to Department of Justice for comment. I've been told that the United States attorneys hate my guts, and the Department of Justice hates my guts, when I actually wrote the book out of a strong love for the Department of Justice, at least what it used to be and what it should be. It's been an amazing journey in more ways than one. When people hear about it, they are absolutely floored, and when they read the book, they're even more floored. But I can't tell you how important it is to take the time to be informed on issues like this. We can make a difference. There is a significant bipartisan effort now to enact criminal justice reform. They have barely scratched the surface with the new bill that has just been reported out of committee in the last week or so. There was much to do about it in the press last week, and there may be again this week, but I'm telling you that is just the tip of the iceberg of what needs to be done. We definitely need to address issues like criminal intent that's not included in this bill at all. There are a lot of people in prison that shouldn't be there at all. I would guess that 10% of our current prison population is completely innocent of what they've been charged with. I don't know if you've watched the work of the Innocence Project at all, but it's almost every day, every week, they're obtaining the freedom of somebody who spent 25 years in prison for a heinous crime they didn't commit. They just got the wrong person. I encourage everyone, when they serve on a jury or get a jury summons, don't look at it as, oh my God, I can't believe I've got to do this. A single juror has a lot of power. A single juror can stop an unjust conviction. If you know any judges, state or federal, they can adopt for every trial what's called a Brady compliance order and put the government or the prosecutor under a specific order to produce evidence favorable to the defense at specific times and make sure that the defendant gets what he's entitled to get. And when you're serving on that jury, if you have a sense that the judge is running a railroad, vote to acquit. Throw a monkey wrench in the whole thing. Vote not guilty. And that's a great way to insist that somebody get a fair trial, because it's not happening in a lot of courts across the country. We do have judges, fortunately, like Judge Alex Kaczynski, who was the chief judge of the Ninth Circuit. In his personal capacity, he wrote the foreword to License to Lie, because this is such an important issue, and spoke with me on the book at the Cato Institute. It's recorded for Book TV. You can watch that if you have any interest in watching any more of Talking Head, Sidney Powell. But Judge Kaczynski is very colorful and one of the highest regarded judges in the country. He's absolutely brilliant, and he knows how important this issue is. He also just came out, for those of you who are lawyers, with a preface to the criminal law, annual criminal law issue of the Georgetown Law Review, that lists changes for our criminal justice system and talks about License to Lie and some of the articles and any number of other things. It's a great resource piece for anybody working on these issues. I think we've got, I'll be glad to take questions. Yes, sir. She's coming with a microphone here.
Thank you. I identify with your frustration. I am a civil attorney, and I am now on 16th year on the simple question of whether the government may prefer one denomination over another. Could you go through the sequence that led you to write the book, and what'd you do when you said, look, I got to write the book? How'd you get started?
I wrote the book because I couldn't sleep unless I did. We had tried to make the legal system work in every way possible. When it got to the point of the bar associations having denied our grievances and completely blown them off, we also tried rehearing, re-request, re-request, the whole bit from each of the organizations we had tried to get to look at the issue. To be completely blown off by them and the court, I just couldn't stand it. So I had to write it. And I literally just sat down and started writing it. It poured out fairly quickly because I lived most of it. There are also any number of events in the book that gave it significant drama, and I left out a lot of things that could have been even more significant drama because it's already 460 pages or so. But there's a murder, there's a suicide, there's a plane crash, there are all kinds of things that happened throughout these cases in addition to the stories of the prosecutors. It has made a difference. I am pleased with that. I've been asked to speak at the Ninth Circuit Judicial Conference. I heard that the U.S. attorneys actually threatened to boycott the conference simply because I was on the program. The Federalist Society, I'm hoping, will ask me to speak on their upcoming panel on prosecutors run amok, because that's exactly the topic that I speak on often. But that invitation hasn't come yet. It wouldn't surprise me if that's not because there's so many federal prosecutors in the Federalist Society. This should be, and I have actually gotten thank you letters from good current and former prosecutors, because the good ones get it. And thank God most of them are good. Most prosecutors work their butts off with next to no resources and try to do it right and get it right. But the problem is nothing happens to those who don't, except they get promoted. As Judge Kaczynski said, the ones who cut corners make it harder for the really good prosecutors, because the ones who cut corners are the ones that are getting promoted and rewarded for their misconduct, and the ones that are really doing the good jobs aren't. I worked for 9 different U.S. attorneys across the country in 3 different districts over a period of 10 years. Not one of them ever looked at my conviction record. Not one of them ever said you can't confess error when the trial attorney's gotten something wrong or you've done something wrong. That's the way it used to be. Why it isn't that way now, I don't know.
In Washington here, we have a very famous set of buildings, Federal Triangle, and a person who was instrumental in the design of that whole area was Andrew Mellon, who was the Secretary of the Treasury of the United States. And I think Andrew Mellon was probably subject to, when you consider what a great human being he was, one of the most unjust prosecutions. I think that's sort of recognized. I know maybe it's not, but it strikes me that what I'm wondering about is, we've seen this in the past. Are we seeing a systematic change, do you think, in the Department of Justice? Is it,
yes.
Okay, and could you talk to that? I mean, how are things different than, the sort of the rogue prosecutor who was bad in the past, or some sort of a targeted sort of situation, political prosecution?
I think high-profile prosecutions, at least with the advent of increased media access and our instant media these days, high-profile prosecutions have become a plum for any prosecutor to be able to get their name in the paper every day. These Enron Task Force prosecutors were called by the Houston Chronicle all-star prosecutors. They described like the MasterCard commercial or Visa commercial, they described their experience as priceless in getting the convictions of the Merrill Lynch defendants. They just get so much publicity and such power that it goes to their heads, or they're the kind of people that seek that out to begin with. Back when we were prosecutors, we were told not to talk to the press. Now, every time there's a high-profile indictment, you see the U.S. attorney out grandstanding with a big press release and publicized perp walk of this person off Wall Street or wherever. I would caution that the more high-profile the prosecution, whether it be Senator Menendez or Haslard or whoever, the more careful and more suspect we need to be, frankly, of the validity of the prosecution. And that's gotten increasingly worse. In the last 6 years in particular, I would say I've seen amazing, what I would call politicization and weaponization of every agency of the federal government to target people because of issues like freedom of speech, their religious issues, gun issues. Department of Justice even has this program I think it's called Operation Choke Point, where they have decided that pawn shops, because they buy and sell guns, and payroll companies and things, or even though they're running perfectly lawful businesses in full compliance with all the unthinkable numbers of laws and regulations that apply to them, this administration doesn't like them. So they have told the banks, under threat of being under greater scrutiny, not to do business with these little companies. Some of those little companies are owned by moms and pops and veterans, and they're being put out of business under Department of Justice threat against the bank. So it shuts down their banking and they can't do business. That's a full-blown program of our Department of Justice that is completely lawless. I find that unfathomable, and nobody's doing anything about it. If you Google Operation Choke Point, you can find a few articles about it. And one of them's one of mine on Eric Holder and his corrupt Justice Department. But we've got that going on with all kinds of agencies. We have increased federal regulation. There's so many regulations that nobody can keep up with what they're supposed to do. Another good book you should read is Harvey Silvergate's book, 3 Felonies a Day, talking about how the average American going about their daily business unknowingly commits 3 felonies every day. There's a Twitter account, Crime a Day, and they tweet out all these different little things that you would never think of are a crime that are crimes. For example, it's a federal crime to get in the fountain in front of the Congress building. It's a federal crime to go in the Library of Congress with an offensive odor. Yeah. You know, what is our Congress doing passing crap like this in the first place? It's like every special interest group or somebody gets offended by something, they want to make it a crime. We have over-criminalized everything. I mean, God did it with 10 rules, right? And add on the golden rule. You got pretty much everything covered. Anything that would be a valid crime probably comes under one of those 10 commandments. But we have hundreds of thousands of pages of codes and regulations and criminal laws now, so many that nobody knows what they're doing, and any overzealous prosecutor can take one of those and put any one of you in prison tomorrow, if that's what they want to do. And some of them are doing it. It's very, very scary. Look at the Wisconsin prosecutions of people that worked with Scott Walker. They were SWAT raided in the middle of their night, law-abiding people at 4 o'clock in the morning, doors kicked in, hauled out of bed and handcuffed in front of their children and taken out for things that amounted to absolutely nothing. And then put under a gag order so they couldn't even talk about it. They couldn't tell the public what was going on. There was a big either New York Times or Wall Street Journal article by Mr. O'Keefe, or about Mr. O'Keefe, not James, the Acorn guy, but one of the Wisconsin men, about what he and his family went through as a result of that wrongful prosecution by the Wisconsin Attorney General, and it was all politically motivated. I mean, politics has no place in prosecutions. We're supposed to be a rule of law country. And instead, we've turned into selective enforcement of law, targeting individuals for their speech, their religion, or not targeting or not enforcing because of religion, not enforcing immigration laws. It's just all backwards.
Thanks for being here today. I'm wondering how this experience, if at all, shaped your view on prosecutorial immunity from civil suit, 1983 suits. I know, I used to work in criminal defense and civil rights law, and I recognize the arguments on both sides, and that experience shaped my view somewhat on this. However, I'm not totally sold that could fix issues like this. I just wondered if you could elaborate on that and just your general thoughts on the remedy and when we talk about fixing the system.
I think it would go a long way, and I'm certainly advocating the abolition of absolute immunity for federal prosecutors, and state ones for that matter. Police officers function with just qualified immunity. They have to react to instant situations where they don't have time to even think, and their lives are in jeopardy. Prosecutors' actions are much more thoughtful and calculated and deliberate than the actions of the police officers. So if a police officer can function with just qualified immunity, a prosecutor shouldn't be allowed any more immunity than a police officer has. And I think it would make a difference. I think if you had to think about being civilly sued if you deliberately withheld the Brady information, and there should be some remedy. My client spent a year in prison, and it's just nobody even said, "I'm sorry." Bill Fuse spent 8 months in maximum security. Nobody even said, "I'm sorry." He has no remedy whatsoever against the government and the prosecutors who deliberately put him there knowing that they were hiding the evidence that would have exonerated him. For anybody else, that's perjury and obstruction of justice, or subordination of perjury and obstruction of justice. And one of the things I just scream about is the need to hold our government to higher, or at least the same standards by which they want to hold all of us. They're supposed to work for us. They should be held to a higher standard. If you're going to walk in a courtroom of the United States of America and say, my name is Sidney Powell, I represent the United States of America, you damn well better know your stuff and get it right before you take away somebody's liberty and property. Now, 80% of the civil asset forfeiture cases, nobody's ever criminally indicted. So we've got this widespread issue of they can just take money out of your car, take it, sell it, do what they want to do with the money. You've got no recourse. Spend your life savings trying to get it back if you get anything. And you're never charged with a crime. There should be no asset forfeiture unless you've been charged with a crime, and then there should be a direct link between the asset and the criminal activity. And we need to find alternatives to incarcerating people that don't need to be in prison. There would be much more effective ways. I mean, I'm no fan of Bernie Madoff by any means, but if I could sentence Bernie Madoff, I'd make him live in Section 8 housing in New York and work in a soup kitchen 12 hours a day with an ankle bracelet on and no access to any computer. Instead, we're paying thousands of dollars a year to house him in Buckner, North Carolina. Yes, ma'am.
Did any of these cases trigger congressional investigations?
No. A number of Senator Hatch held this book up to Loretta Lynch in her confirmation hearing and encouraged her to read it and clean up the Department of Justice. But no, in fact, I've offered to testify in front of some congressional committees on overcriminalization and corruption in the Department of Justice, and no invitation has been forthcoming. Another interesting point, after the Stevens report came out, the 500-page report of the special prosecutor in the Stevens case, it was just a scathing indictment of the Department of Justice and how calculated they were in that misconduct. Aside from the fact none of the prosecutors were disciplined in any way, I just completely lost my train of thought on that. Nothing happened with the congressional inquiry. There was none on that either. I think one prosecutor actually got served 1 day of a 40-day suspension. Another one was assessed a 14-day suspension but didn't serve any of it. 3 of them still work for the Department of Justice. Others went on to higher paying positions in private sector.
You've mentioned several people who have ties with the Obama administration, but are the problems that you're describing something unique to the Obama administration, or are they something you've seen in other administrations?
Definitely go through the last 2. But of course, it wasn't known at the time Friedrich was appointed as acting assistant attorney general for the criminal division to micromanage the Stevens prosecution. We didn't have the evidence that we have in this book now. But at the same time, I don't see the standards having been enforced under the prior administration any better than I see them enforced here. It's like each administration has gotten worse in allowing prosecutors more unfettered discretion and failing to hold them accountable when they do something wrong. I mean, people are going to make honest mistakes. If these had been honest mistakes, you can come forward and say, I screwed this up. We should have fixed it. But as an example of the fact they did not get the message from the special prosecutor's investigation in the Stevens case, you can look to the United States Court of Appeals for the Ninth Circuit decisions in Kott, K-O-T-T, and Kohring, K-O-H-R-I-N-G. The Department of Justice said, it didn't matter. Same witnesses, same kind of conduct, related cases to the Stevens prosecution. They tried to defend both those convictions by saying it wasn't material to the defense, the evidence they withheld about the same witnesses. And Judge Betty Fletcher went ballistic. She wrote a scathing dissent. The Ninth Circuit reversed both those cases. But she said the court should have gone even further, that the Department of Justice had obviously learned nothing from the reversals or the conduct in the Stevens case, and she would have dismissed the indictments under the court's supervisory authority for their misconduct. That's what's going to have to start happening, and that is starting to happen. The judges at the Ninth Circuit were receptive, at least listening to what I was talking about. A lot of judges I know now have read the book. District judges as well as Ninth Circuit judges need to do a whole lot more to get the book out there, because distributors are not being helpful. Amazon won't even give me the buy box. They'll report that they're sold out when I've got 350 copies sitting there as a vendor myself in their warehouse. So you have to go to third-party seller to get it by Amazon, and it's been amazing, really amazing. I would never have thought that our media is as controlled as it is. Never.
I was wondering about the sort of recent set of, I don't know if in the financial meltdown of 2008, you have all these sort of banking cases, right? A lot of them stem from things where these companies were forced to take on assets, and then they prosecute. It's
a revenue stream.
Well, right. So you have these massive settlements that have occurred, tens of billions of dollars and these sorts of things. So could you talk about that what is going on there? I mean, if you're going to charge somebody, then charge them. But this just seems like a shakedown.
It is a shakedown. It's a very calculated, very well manipulated shakedown of corporate America. Google paid $500 million to the government to avoid an indictment for advertising for people on Google's ad policies and sites and whatever. I never have understood what Google does. But and FedEx now has been indicted. They're the only ones that I know of that are fighting back. The government wants like $1.2 billion for them for shipping drugs from Canadian pharmacies to wherever they were supposed to be shipped to. FedEx has no responsibility for what's in the containers. It doesn't know what's in the containers. And on top of that, the government, FedEx, had asked Department of Justice to give them a list of the pharmacies that were, quote, prohibited, questionable, whatever, and DOJ wouldn't give them a list. And then indicts the company and wants $1.2 billion. And then where is that money going? All I've heard is that there is a slush fund, basically, within the Department of Justice, and they feed it out to whatever little groups they want to feed. Housing issues, whatever.
So it's sort of like a slush fund for community organizing or something,
right.
Some kind of political slush fund that I doubt is going to social conservative organizations that defend, life, for example. I don't think we've been invited to that party.
I'm sure you have not been invited to that party. Yeah. Another interesting thing, I actually funded this entire project out of my own pocket. And I was going to list on my website, I thought I might actually generate a profit at one point, so I was going to donate the money to 4 charities that defend the indigent. All of them asked not to be put on my website because they get DOJ money. And they didn't want to be affiliated with this book. That's how afraid everybody is of our Department of Justice. If you can find the picture when Jamie Dimon had a one-on-one meeting with Eric Holder, if you can see the footage online of Dimon coming out of his one-on-one meeting with Eric Holder, he didn't even look like the same person that went in. Whatever Holder said to him terrified him. He probably threatened to shut down J.P. Morgan.
And the Andersen case would bear that out, right?
Yeah.
And then, now they have this scalp on the wall that they can always point to.
Yes. And now they've figured out that if they work it all out ahead of time carefully, they can indict the bank and get the money on the same day because they've pre-worked the whole deal. And it's not so bad. It doesn't kill the company. It just assesses another major penalty against them and feeds the slush fund. We need to have a major congressional inquiry on the accounting for the money that has come from all the banks in just the last 4 or 5 years, or any other company for criminal indictments. It's going to get worse. They've already announced, with Weissman coming in as head of fraud section again, and of course Caldwell as head of criminal division, and Loretta Lynch. They don't mention her name when they do this. I've noticed, they used to mention Holder's name with everything. You almost never hear Lynch's name, but they've announced another policy now to go after business and banking executives personally, just like the kind of Enron white-collar crime task force that started all of this mess to begin with. So we're getting ready for another cycle of that.
Well, I wish we could say it was a cheerier topic, but I think but we believe that like public integrity is important, and it's part of the great tradition of being an American and not being in some country where political corruption. I mean, I was just reading the other day that the wealthiest person apparently in Venezuela is Hugo Chavez's daughter, who happens to be worth $4.5 billion. I don't think we want to go in that direction when you have slush funds being set up in the Justice Department and all these sorts of things happening. How far are you away from,
Right.
Things are not going in the direction you want, and things have to be straightened out. So thank you for coming in and lecturing us. And,
Thank you.
Talking about your book. Thank you for your courage in writing it.